All right, let's bring up these slides full screen. There we go. All right, welcome everyone to our second courtside of this fellowship. If you recall, at the first courtside, we answered all of your questions about the Supreme Court. We talked about what the shadow docket was, and we previewed what cases were going to be coming up. Well, since then, as you know, there was a really important case that was heard yesterday, two cases actually, and they were heard on an emergency basis, which rarely happens on the Supreme Court. They were not expecting to hear these cases, but the court thought it was so urgent that they granted emergency cert, writ of certiorari, and here we are. These cases are colloquially known as the Texas abortion cases, but they actually don't have that much to do with abortion, as we're going to see. These are more procedural cases with a very kind of specific legal argument in mind. The court is actually taking up a full-on abortion case in December, which we can also talk about that case. And that case is going to be deciding on the merits whether Roe v. Wade, the case that found a right to privacy, which enabled abortion to take place, whether that case whether Roe v. Wade should be overturned. But we're not going to talk about Roe v. Wade today. We're not going to talk about abortion necessarily. We're going to talk about the legal side of things. So quick history. The first thing we're going to do tonight is start with a quick history of SB 8. That's the law that is at issue here in Texas. We're going to talk about why there are two cases. Why aren't there just one case? We're going to talk about who's on each side of this argument. We'll talk about each side's argument. Then we're going to listen to pieces of Monday's oral argument. And then I have some questions for you to consider and some final thoughts. As always, though, if you have questions during the early stages of this session, please let me know. I can't see the chat because we're in full screen. So you're either going to have to raise your hand or just turn on your camera or turn on your audio and just go ahead and ask. And I'll pause at the end of each slide also to allow for questions. Okay, so let's start with a quick history of SB 8. On September 1st of this year, Texas enacted a law that empowered private citizens, really anyone, to sue abortion providers, so abortion clinics, as well as anyone who aids or abets the abortion clinics in state court, in Texas court. This law lets anyone sue if an abortion takes place after 6 weeks into pregnancy. The general consensus around viability of a fetus is around 24 weeks. That's what Roe v. Wade stipulates and a couple other Supreme Court cases. So this case took a much earlier approach and was allowing anyone, not just a state official, anyone who wanted to, even if they lived outside of Texas, to file a lawsuit like this. So you're probably wondering why would Texas structure a law like this? Other states have put in laws that were restrictive of abortion, but they always allowed state officials to do that oversight, never private individuals. So Texas structured the law this way because they knew that if they outright banned abortion, that would violate the Supreme Court's Roe v. Wade ruling, and it would result in lots and lots of litigation. So Texas did this, and now they're arguing that the federal government can't stop this law, right? Because they can't stop private citizens from filing these lawsuits or prevent state courts from hearing them and awarding damages. Texas is saying, this is not a state action. This is just completely private. And you should note that the person that brings this lawsuit against an abortion provider or someone that helps an abortion provider can get up to $10,000 per abortion plus attorney's fees from the other side. So they structured this in a way to incentivize people to want to file these lawsuits. Critics of the law, including the Biden administration, which we're going to talk about, they're arguing that this law creates a bounty system. It's effectively turning regular people into bounty hunters that would allow anyone to prevent a woman from exercising a right that has been guaranteed in Roe v. Wade. The case, like we know, reached the Supreme Court shadow docket in September. It was a very highly controversial decision. But in that initial case, before they heard any arguments, before they had any written briefs, the court ruled 5-4 to let the Texas law stand. Now, in the months since then, lots of people were upset by that. There was a big public outcry over that decision on the shadow docket. And so the court just 2 weeks ago abruptly scheduled this full oral argument that took place yesterday. Any questions about this basic history of the case before we keep going? Okay. So why are there two cases here? I mentioned that earlier. What's the deal with these two cases? Well, the first, oh yeah, go ahead, question.
I was gonna ask, what's a shadow docket?
Yeah, so a shadow docket means the case is not heard, it's not fully heard, right? It's not heard in the light of day where people get to ask questions and we get to hear the oral argument. Shadow docket means it's the case is heard in the shadows. We have no idea what happened. We never heard oral arguments because there were none. We never saw full briefs from either side because there were none. It was done in the shadows. And that's what a lot of people were upset about, is that the case wasn't fully heard. The shadow docket's meant to be used for real emergency dire circumstances, that when a case can't wait. So for instance, when someone is on death row and they might be about to be executed and there's a last minute emergency appeal to the Supreme Court, that's a proper use of the shadow docket. Whereas a lot of people thought that this use of it was not proper.
Okay, thank you.
Yep. Okay, so why are there two cases? The first case was a group of abortion clinics in Texas that became known as Whole Women's Health. They sued the judges and clerks in the Texas courts who would preside over these bounty hunter lawsuits. And they did this proactively. They did this before there were any cases actually being brought. And the Supreme Court initially didn't think they could do that. That was part of that 5-4 shadow docket decision, is that they said, hey, no one's even brought one of these bounty hunter cases up yet. So we have nothing to rule on. And now they're taking up that case. And the other case that's before the court, which is dealing with the same issue, is brought by the US Justice Department. And the Biden administration agrees with this. And that case is called US v. Texas. The United States Justice Department is suing the state of Texas. That's a power that's unique to the federal government. A private citizen can't just sue the state of Texas. There needs to be a reason. There needs to be that there must be some law that's unconstitutional there. So the Justice Department sues Texas itself, and that includes anyone that's carrying out the Texas law's commands. So that's why there's two cases, and they were heard at the same time. The oral argument was almost over 3 hours yesterday, and I listened to it. That way you didn't have to listen to the whole thing, and we're going to just pick out the most important pieces of it. Now, who's on which side of this argument? Some of the groups here might surprise you. As we talked about last time, you might be wondering, how do I know who's on each side? Well, it's because different interest groups can file what are called amicus briefs. And these briefs are friend of the court briefs. And they let us know how other groups feel about this. Really, anyone can file one. If you feel really strongly about a Supreme Court case and you know how to write a legal brief, you can file one with the Supreme Court and get it on the record. So here are some of the groups that are on the side of the abortion clinics and the Justice Department. First, no surprise, pro-choice groups like Planned Parenthood are on their side. Second, the Biden administration, again, no surprise, because the Justice Department is filing this lawsuit. Third, the state attorney generals from Democratic-leaning states, again, no surprise. The American Bar Association, so this is an association of lawyers. And then finally, this one is a surprise, the Firearms Policy Coalition. So this is a group that is meant to protect the Second Amendment, protect gun rights ownership. And we're going to talk about why they're on the side of the abortion clinics in a minute. One of the justices brings this up in the case. And then on the other side, who is on the side of Texas and of this law? Well, again, unsurprisingly, pro-life advocates and pro-life groups are, because this law restricts abortion access. Second, the Beckett Fund for Religious Liberty. So there are a lot of religious groups that are in favor of this Texas law. And then third, attorney generals from Republican states. So Republican state attorney generals. Again, not a surprise there. Any questions about who's on whose side here? Okay.
Why is the or at least the Firearms Policy Coalition?
Yeah. So you're going to see that they're worried about other states putting in a law that's just like this Texas law, but instead of the law restricting abortion rights, they're worried that, say, a more blue state, a Democrat-leaning state, would pass a law restricting gun rights based on this same principle. And they don't want that. And so that's why they're against this Texas law. I mean, you're going to see that one of the justices really hammers home this point in the oral argument. Okay, so what are the basic arguments from each side? We touched on this a little bit, but before you hear the case, I want you to hear what these arguments are and have them in your head as we listen. So first, the abortion clinics in the Justice Department. This is what their argument is. They first say that this law creates a bounty hunter system that allows anyone the ability to prevent women from exercising their constitutional right that's been guaranteed by the Supreme Court and reaffirmed in Roe v. Wade. Second, they say that the law that Texas passed has what's called a chilling effect on anyone who wants to get an abortion and potentially challenge the law. A chilling effect means that people aren't going to challenge the law because they're scared that they're going to lose and have to pay the $10,000 fine. And you're going to see that Justice Roberts, the Chief Justice, really hammers home this point in one of his questions. Third, they argue that if this law were to stand, every state or most states would pass similar laws to this that would infringe on individual rights. And this would violate the Supremacy Clause, because what states would be doing essentially is nullifying rights that are guaranteed to us in the Bill of Rights. So you could imagine that a state could pass a law infringing on free speech rights, or Second Amendment gun rights, or Fourth Amendment search and seizure rights, and so on. And so the argument that the clinics in the Justice Department is making is that we can't have this. It would essentially be chaos, and it would violate the Supremacy Clause, which states that federal law is supreme to state law. So that's the clinic Justice Department side. Now, Texas, on the other hand, says federal government has no ability to intervene here. None of these cases have even gone to court yet. It's unprecedented for the federal government to be intervening when we don't even have anyone that's actually challenged the law. We haven't even had one of these lawsuits go forward, so there's nothing to challenge here. And then second, Texas says the federal government should not be able to stop private citizens from filing these lawsuits or prevent state courts from doing their job and in hearing these lawsuits and awarding damages. So it boils down to federal government really has no jurisdiction here, really has no right to get involved in these private citizen suits in Texas. Any questions on those two sides of the argument?
Yes.
Go ahead. I'm not sure why there's an echo. Do you have
Yeah.
phone in your
Can you hear me now?
Yes.
Okay, so I have a question. Like why the federal government cannot intervene according to Texas?
Say that again. Why the federal government
Cannot intervene according to Texas?
Yeah, so Texas is saying that there's nothing to intervene on. They think that what needs to happen is someone someone needs to have an abortion, then someone needs to sue that person under the Texas law, and then that case needs to work its way up through the courts. But that hasn't happened yet, and so Texas is saying you can't intervene if there's been no case, that this is unprecedented. And if we allow the federal government to intervene here, like who knows what else they're going to intervene on. And a couple of the justices picked up this argument. So Justice Gorsuch and Justice Alito, they both kind of agree with this line of argument that it would be unprecedented for the federal government to intervene here. Good question.
Yes, thank you.
Okay, so what we're going to do now is we're going to listen to some clips from the arguments, and we can discuss. We're going to have you can ask questions, etc. So the first piece I want to play for you comes from the Chief Justice, Justice Roberts. What he did is he posed a hypothetical question to the lawyer for Texas. Roberts asks that instead of a $10,000 bounty, imagine the bounty would be $1 million. And so if someone wanted to sue someone for having an abortion in Texas and they won, they would get $1 million. So Roberts says, does that change anything here? Would that have more of a chilling effect? You're going to see he doesn't like the response he gets, and he gets a little bit snippy with the lawyer. I wanted you to hear this. I'm going to turn the volume way up to make sure you can hear.
Anybody having the capacity or ability to go to the federal court, because nobody is going to risk violating the statute because they'll be subject to suit for $1 million. That takes a lot of fortitude to undertake the prohibited conduct in that case. And under the system, it is only by undertaking the prohibited conduct that you can get in the federal court.
Excuse me.
That is a significant difference. My question is what we call a hypothetical. Of course, Mr. Chief Justice.
Question?
There was this problem with the audio, like it sounded like
Fuzzy?
It's fuzzy.
Yes.
Okay. Yeah, I was a little worried about that because it's picking up from my microphone. What I can do is share my computer audio. 1 second. Okay, I think you'll be able to hear it better now. 1 sec.
Would suddenly cause the federal courts to become more open. It's not a question of the federal courts being more open. It's a question of anybody having the capacity or ability to go to the federal court, because nobody is going to risk violating the statute because they'll be subject to suit for $1 million. That takes a lot of fortitude to undertake the prohibited conduct in that case. And under the system, it is only by undertaking the prohibited conduct that you can get into federal court. Well, Your Honor, individuals, again, to the extent that we're dealing with the sorts of very high stakes prohibited conduct, fines, sanctions, etc., I might add this is specifically a damages action. It is capped at much less than that. That is a significant difference. My question is what we call a hypothetical. Of course, Mr. Chief Justice.
Okay, so that piece at the end where he said, my question is a hypothetical, and the lawyer said, of course, Mr. Chief Justice, it's a hypothetical. That's about as snippy as Supreme Court oral arguments get, because the lawyers obviously have to really defer to the justices. And you could tell there that Roberts was not happy, that he kind of dismissed his hypothetical. And that's just not something that they expect of an attorney. Any questions or comments about that clip from Roberts? Could you all hear it?
I could hear, but I wasn't exactly sure what he was getting at.
Yeah, so that piece, I really just wanted you to hear like Robert's annoyance there. You don't have to worry about what the attorney's response was. He was basically just not answering Robert's question the way that he wanted to.
Okay.
Okay, I'm gonna bring up the slides again. Sorry, I'm gonna have to switch back and forth between sharing audio and sharing slides.
Okay, so I have a question that's not really related to Justice Roberts, but let me get this right, or let me have a fresh start here. So anyone can sue anyone for having an abortion.
Yes.
Oh, so that means someone who is not from my family can sue another person from another family.
Correct. So the
Wow.
law allows anyone to sue anyone for having an abortion. That could be not even the person that had the abortion or the person that performed it, but it could be someone who aided and abetted. So it could be someone, if you drove someone to an abortion clinic, if you helped advise them on where to go to get an abortion, you could also be sued for $10,000 under this law.
Wow, thank you.
Yep. Okay, so here is Justice Kagan. We're going to listen to this piece where she calls the authors of SB 8 geniuses, but not in a good way. You're going to see that she refers to them geniuses in a mocking way. And she wonders how a state could possibly nullify federal constitutional rights like Texas is trying to do here. So let me switch to audio, and then we're going to listen to this. Here we go.
And if this court is going to stand by its
General
word,
Stone, I think what Justice Breyer is suggesting is that the entire point of this law, its purpose and its effect, is to find the chink in the armor of Ex parte Young. That Ex parte Young set out a basic principle of how our government is supposed to work and how people can seek review of unconstitutional state laws. And the fact that after these many years, some geniuses came up with a way to evade the commands of that decision, as well as the command that the even broader principle that states are not to nullify federal constitutional rights. And to say, oh, we've never seen this before, so we can't do anything about it. I guess I just don't understand the argument.
Okay, so that's a pretty extraordinary thing that Justice Kagan is saying there. She's saying this is so unprecedented, never seen anything like this, that she's almost like dumbfounded by this law. What do you think of that? And what do you think of her calling them quote unquote geniuses?
Well, oh yes, go ahead. Sorry.
Oh, I was gonna say, I think this is, I guess kind of just reiterating what you're saying is she's, I mean, like surprised that someone was able to do this. Like, she thought it was pretty like set in stone that something like this couldn't happen, and like how this is even an issue. And like that has come up is, I guess, perplexing to her.
Yeah.
Yeah, I think the audacity these people had to actually make a loophole in the law to restrict abortions, like unbelievable.
Anyone else want to chime in?
That's, I think, like that is sort of like to the point made of like it's a very creative law in the sense that like it does find this like workaround that nobody has ever done before, but like isn't necessarily like isn't following the same, like, how am I trying to say, like like what the actual intention of like the constitutional things are.
Right. She's almost saying like, imagine our constitutional system is like a marathon where everybody is like running. Like we've all accepted the rules that to do this, you have to run those 26 miles. Justice Kagan is saying is that some geniuses decided to use a bike instead to run that race and get around those rules. She's saying it in kind of a mocking way that it's like so far outside the way that constitutional law is practiced and done that she doesn't even know what to do with it, and to suggest that because it is so different that there is no remedy, she thinks is kind of crazy. All right, let's listen to one of the conservative justices. So this is really interesting. Justice Kavanaugh, generally seen as more conservative. He questions what other states will do if SB 8 is allowed to stand. And so listen to what he says a state might do to prevent access to guns. He sounds skeptical that states can just insulate themselves from federal review or federal oversight by enacting SB 8 style laws. So here is Kavanaugh.
Your position for other constitutional rights. The amicus brief of the Firearms Policy Coalition says, quote, "This will easily become the model for suppression of other constitutional rights, with Second Amendment rights being the most likely targets," end quote. And it could be free speech rights, it could be free exercise of religion rights, it could be Second Amendment rights. If this position is accepted here, the theory of the amicus brief is that it can be easily replicated in other states that disfavor other constitutional rights. Your response?
Your Honor, in several of those circumstances, individuals who are concerned that a lack of immediate pre-enforcement federal court access would cause them ruinous liability or otherwise suppress their ability to exercise those rights have turned to Congress and succeeded. The Protection of Lawful Commerce and Arms Act, for example, was specifically passed in response to state tort lawsuits in which there was no immediate federal review that could only at most be brought here.
Well, for some of those examples, I think it would be quite difficult to get legislation through Congress. Are you saying, absent that, that Second Amendment rights, free exercise of religion rights, free speech rights could be targeted by other states in this, using the Ex parte Young language on 163, and to really infringe those and to put huge penalties to the Chief Justice's hypothetical, say everyone who sells an AR-15 is liable for $1 million to any citizen. Uncertain what the Second Amendment status of that ultimately will be, which is where those laws will have purchase. Would that kind of law be exempt from pre-enforcement review in federal court?
So I know there was a lot going on there, but it's really that example at the end that he gave where he said, what if a state could just put in a law that says anyone who sells an AR-15, you can sue them for $1 million. What do you think of that reasoning from Justice Kavanaugh?
Well, actually, following that logic, any state could create a law saying, oh, if you promote abortion, you can even get killed or harmed. Like people having permission to use guns to reduce abortion. Like following that logic, states can create their own laws to reduce abortion in harmful ways.
Right, and following that logic, he's saying that other states could do this, put the same kind of law in for other rights, for free speech rights, for gun rights, for search and seizure rights, for religious rights, etc. What could stop a state from saying, well, let private citizens sue people from practicing a certain religion and give them a $10,000 bounty if they do, if a state doesn't want some type of religion practiced, right? There's nothing that would stop states from doing that if this law were to stand.
All the efforts to make a country that accepts all backgrounds is are being destroyed. Like, we're going backwards with this kind of law, in my opinion.
I'm wondering, in relation to like towards the firearm thing and relating it to like this abortion case, how would that work? How would states enact, like, you see someone to, like, I'm trying to wonder like how it would apply to other constitutional rights.
Yeah, so the state of New York could pass a law that would allow for any person, any private citizen, to sue a gun seller, so like a gun shop, for $10,000 if they sell AR-15s, like automatic rifles. And then people would stop selling those guns, just like people have stopped having abortions in Texas, because they're not going to want to sell those guns here and be subject to a $10,000 penalty. Does that make sense?
Yeah, I think I can't remember where, but I think it's reminding me of, I think maybe Detroit or Chicago, but I know there's some place where like certain guns aren't allowed to be sold, but they just go to like outside neighboring like rural places to buy them.
Right.
I can't.
So it's the same thing. So Texas would say, you could still get an abortion in a different state, right? You could cross state borders to get one, just like New York could say, you could still cross state borders to get a gun. You could go to Vermont, say they have looser gun laws, and get a gun there. But then you'd have every state kind of crafting their own way around these constitutional rights. And so, one side might want to restrict abortion rights, one side might want to restrict gun rights, but those are, both protected in the Constitution, according to the Supreme Court.
Okay, thank you.
Yeah. Okay, so let's listen to one more. This is Justice Kagan again, and you're going to hear her agreeing with Justice Kavanaugh, which is sometimes rare, because they generally are on opposite sides of cases that come down to like deeply held either liberal or conservative beliefs. So here we go. Let's hear what Justice Kagan says.
Question about that, though. I mean, if that's right, and we say that, we would live in a very different world from the world we live in today. Essentially, we would be inviting states, all 50 of them, with respect to their unpreferred constitutional rights, to try to nullify the law that this court has laid down as to the content of those rights. I mean, that was something that until this law came along, no state dreamed of doing. And essentially, we would be like, we're open for, you're open for business. There's nothing the Supreme Court can do about it. Guns, same-sex marriage, religious rights, whatever you don't like, go ahead.
Respectfully, Your Honor, I have to disagree with you on 2 points. The first one being the state of Texas has nullified anything. The state of Texas specifically set up in state law a recognition of this court's holdings in Casey, providing an undue burden defense, particularly to recognize that this court's holdings bind state courts in their adjudication. And of course, the federal constitutional right can and must be made available in those state courts regardless. The second point being, to the extent that we're talking about sort of the extremist hypothetical where it's a $5 billion sanction, and by the way, court is on the moon.
But by the way, this seems a pretty extremist hypothetical actual, I mean, because the actual provisions in this law have prevented every woman in Texas from exercising a constitutional right as declared by this court. That's just not a hypothetical. That's an actual.
That's just not true, Your Honor. There's evidence in the record that estimates that the number of abortions occurring right now in Texas is between 50 and 63%.
I'm sorry. You're exactly right. I should have said every woman in Texas who has not learned and has not made a decision before 6 weeks.
Okay, so she was again taking up the same line as Kavanaugh. saying that like what would happen if other states pass laws like this, and then you can see that it gets a little heated between the two of them, where she's saying that this is an extreme law that you have here. The lawyer was saying that the hypothetical was extreme. What Justice Kagan is saying, like what Texas has done is actually what's extreme here. So let me pull up the slides again for you. Any questions or comments on what Justice Kagan just said?
Sorry, go ahead.
I was just gonna say like with like I think it was like in the section with the attorney like talking like answering like Kavanaugh's question.
Yep.
But like the idea, like if I was hearing it correctly, of like, well, if the federal government wanted to act on this, like they could make a law that would like prevent the states from making a law like this. And that idea of like how some of those wouldn't necessarily pass through Congress very easily, and how it's like sort of odd, the idea of like Congress passing a law that would like ensure people could have a constitutional right, which is sort of like an odd like thing.
Yeah, I'm really glad you picked up on that. I can't see, is this Oliver? I can't see the name here.
Yeah.
Yeah, no, great point, Oliver. So this is something that Kagan got upset about earlier in the argument, is when the lawyer suggested exactly as you said, well, Congress can do something about this. Congress can reinforce these constitutional rights. But Kagan's position on that is Congress, first of all, Congress can't get anything passed. Like there'd be no chance for them to pass that, and they shouldn't have to. These are constitutional rights. These were passed by the framers of the Constitution or through the amendment process. There is no reason for Congress to have to reinforce constitutional rights. They cannot be usurped, and so that I think that's where a lot of the justices are going to fall on that side of the argument. So I'm really glad you picked up on that.
And I think like to just sort of like maybe hinting at some of like because it's like sort of the creative workaround, like I feel like when you get those like weird things, like it's sort of hinting at like some of the flaws where like if you're running into a situation where like Congress needs to pass a law to like ensure a constitutional right, then like we're sort of in a weird place.
Right. Exactly. Very good point. I'm not going to play this clip, but I want you to be aware of what happened with Justice Coney Barrett, the newest justice on the court. She is generally known to be more conservative as well, like Justice Kavanaugh, but many people think she's actually going to be in favor of overturning this law. And that's because in the clip that I won't play because it's pretty long and I want to get to hear some more your thoughts. She thinks that the Texas law may be unconstitutional because it doesn't allow the abortion clinics to fully vindicate their constitutional rights in state court. She asks this question of the lawyer for the clinics, and she's essentially giving him a softball question. So whenever a justice asks a question of an attorney that they're trying to help, it's like formed in a way that's they're going to respond yes to. And so the attorney in this clip just kind of agreed with Justice Coney Barrett here. So people were a little bit surprised that she might fall on this side, but that's the way that it's looking. All right. I might have biased you already, but I want to hear your thoughts. After hearing a little bit about the case and about and hearing some of the clips of the oral argument, which way do you think the court will rule in this case? Do you think they will overturn the Texas law, or do you think they will let it stand like they did originally in their shadow docket review?
I think they'll overturn it because of the precedent that it could state. Yeah, but that's essentially it. I think will be overturned.
Okay.
I also think that they would overturn this law because they already said that that it's a constitutional right and that state law is above federal law.
Great. And just kind of going along with that, did any of the justices surprise you, either in their comments or questions, or in the way that they're kind of leaning towards ruling?
I think the last bit about ABC surprised me, but in regards to the other justices, I wasn't too surprised.
Gotcha. So this one, you know, none of you may agree with this, but I'm just curious. Does anyone want to make the argument that states should be allowed to pass laws that let private citizens collect bounties when suing people for violating a law? Can you think of any circumstance where this actually might be beneficial, where this would be help the public interest or help the public good?
I guess to answer the first question, I would be like, no, I don't think states should be allowed to pass laws because this can very much, I don't know, this is very reminiscent of, so I'm thinking of, what is it, the witch trials from the Crucible?
Yeah.
I read in class. But yeah, it's kind of, I think it kind of leads to that back and forth, and just some people might even like make it their job, as in they're just trying to look for people violating laws so they can like collect bounties. And then in a circumstance, like if I had to find a circumstance where this would be beneficial, say maybe an adult is like helping purchase alcohol and drugs for minors, and someone like calls them out on that, or I think maybe that in that sense it would be beneficial.
Yeah, that's interesting. You know, I'm sure, you know, Texas is probably making like a public health argument as well. To your point, you can envision maybe a state wanting to allow people to sue for something like that would potentially be harming minors. That's really interesting.
I think that it can be beneficial, but if they have a limit, so it doesn't become a job. For example, if you just have like two maximum of, I don't know, of X amount a month and a low amount, so that if you spot something wrong in a situation, you are like encouraged to accuse them and for justice to be made, because a lot of times like people just prefer not to complicate themselves and not present and not sue anyone. So I think, but also if it is without the limit, it will just make like things might arise, such as, I don't know, privacy of people or even false claims. And I think that is a way like to somewhat regulate it.
Yeah, and I think you're right about the penalty too. And that was Justice Roberts' point, is that, you know, at $1 million, that's obviously so high that it will have this chilling effect. No one will challenge the law. At $10,000, that's also seemed to have a chilling effect. You know, maybe if it was $500 or $100, would that change things? Because it might not have the same chilling effect. I don't know. Interesting, open question.
I agree the price shouldn't be so high as $10,000.
Thank you.
I think,
now,
like,
last question here. So if the court were to allow this Texas law to stand, what do you think other states will do? We already talked about the gun example, that some states might pass a similar law around gun rights. Can you think of anything that you could envision for that other states might try to do?
I mean, as like I was sort of thinking, like, I think that's one of the things that's interesting about the law is that like there are cases like I think that is a really good example of like, you know, alcohol and drugs like for minors, like you know, like there are like, you can think of like a really practical use of the law that would be like, that would seem reasonable, but like there aren't like limits to like the extent and like the extremes that you can necessarily bring the law to. So like, I feel like it's one of those things where you can think of using it for like those practical cases, but then like, where's the point that it becomes like to the extremes of like constitutional rights and like those issues?
Right. So what would be interesting is if a state adopted a similar structure for something that's not a fundamental right. So for instance, like you said, like drinking alcohol or drugs, like that's not a fundamental right that's in the Constitution. Or maybe like something around driving violations, or who knows, just anything that's not a fundamental constitutional right. It would be interesting to see how the court deals with that. And they might have a different analysis then.
Like, I guess in relation to question number 4 as well, not necessarily what states would do, but I'm thinking of a state. I don't know, like Utah. I know they're it's fairly conservative there, and it's what is it? Like Mormonism has like a large influence in that state, and so I was wondering, since a large population of like that's of Utah like practices that religion, whether you would see in states that have like large religious holdings, whether you would start to see less of a separation between church and state.
Yeah, that's interesting. I think that's one of the things that both Kagan and Kavanaugh, which they're normally on different sides of things, that they're in agreement about, is that they would both be worried about states using this to influence religion in some way. Kagan is Jewish, Kavanaugh Catholic, and I don't think either one of them would want anyone infringing on either of those religions or any other religion, right? That's one of the beautiful things about America is, that's protected in the First Amendment, freedom to practice your religion. So if some states were to enact a law like that, I think it would be analyzed in the same way here. Okay. Oh, go ahead.
That's like, okay, just last thing. I think like this law really depends on like how it's applied in like certain circumstances, like we mentioned earlier, like if it's applied to like alcohol and drugs and like smoking for minors, then I think it could be used to like a beneficial cause, for like a social cause. But if it's used to curtail like freedom of speech or religious practices, then I think it could do more harm. And so I think it really like depends on how certain states use it. And if it were to be, like, if it was to stand, then I think it would be very like controversial and would need a lot of like more court cases and hearings to like sort everything out.
Definitely. Thank you for that analysis. I really enjoyed that. So here's my prediction for the outcome. You can take it or leave it. I'll probably be totally wrong about this, but after listening to all the arguments and reading up, my sense is that the court's more liberal justices, so Kagan, Sotomayor, and Breyer, are definitely going to side with the clinics and the Justice Department. And then on the conservative side, I think Roberts, Kavanaugh, and Coney Barrett are also going to support the clinics and the Justice Department, but for different reasons, right? For different reasons. Kagan, Sotomayor, and Breyer, I think are want to be protective of abortion rights and are worried about what this law might look like in other states. Whereas Roberts, Kavanaugh, and Coney Barrett might have different reasoning. They might not be as concerned about abortion rights, and we'll see how they vote in next month's abortion case. They might be on the other side of that one. So this case has kind of brought together a unique coalition. I'll also add that I don't think they're buying the Biden administration's argument in the Justice Department that the federal government can intervene here. I think they're more persuaded by the abortion clinic's case that they're the ones who are truly harmed, that the women in their state are the ones that are truly harmed, and that they are the ones who are due a remedy. So the court might fine for the abortion clinics and not for the Justice Department, and just kind of it won't have any impact on the law. The law would still be struck down, but I think the effect will be to side with the abortion clinics. Now, on the other side, on the Texas side, I think it'll simply be Justice Clarence Thomas, Sam Alito, and Neil Gorsuch. They didn't seem to be too convinced by the lawyers for either the abortion clinics or the Justice Department. Any questions on that before we wrap up? Does anyone disagree with that? It's okay if you would need more time to think about it. Does anyone think that I'm kind of off here on this reading of it?
Yeah, maybe it will be like that, but I'm not sure if the questions, well, I really don't have the knowledge you have on Supreme Court, but I also sense that perhaps the questions doesn't indicate that a person is in favor or not, but also if they want to know more and to have more information to make a criteria.
Okay.
And Nick, another thing, I'm sorry, but what was the other abortion case?
In Texas. Yep. So this is all taking place in Texas.
No, but the one you said that might be different in the future.
You're perfect timing. Yeah. So it's on this slide actually. So on December 1st, the court's going to hear a direct challenge to Roe v. Wade. And this case comes out of Mississippi. It's called Dobbs v. Jackson Women's Health Organization. Here, the state of Mississippi passed a very straightforward law. They banned abortions after 15 weeks of pregnancy, and they gave the state the power to enforce it. So, nothing like the Texas law allowing private citizens. Like, this is a traditional, regular old law, bans abortions after 15 weeks. And so that case has been challenged up to the Supreme Court. And so that's where we're really going to see what the court thinks about abortion rights. And that's where you're going to hear a lot more back and forth about this fundamental right to privacy that the court found in Roe v. Wade. And it's through that right to privacy that women have the right to get an abortion in this country. So what could happen is that the court strikes down this Texas law, and then it becomes irrelevant because a month later, they agree with the state of Mississippi and they overturn Roe v. Wade. That's totally possible. And so the justices here that want to overturn SB 8, Roberts, Kavanaugh, Amy Coney Barrett, they might not feel the same way in this case in December. And so we have to, wait and see next month. I'm going to do another session on that. We'll do the similar where we'll let the argument play out, and we'll see if we can glean anything from the justices. But it'll be really interesting to compare what they're saying in that case versus what they said in these Texas cases. Are there any questions or comments before we wrap up?
I suppose I just have a question of, because you said that you listened to like all of the arguments, what were you actually listening to the arguments through? Because that would be like interesting for some cases.
Yeah, SCOTUS blog. I'll put it in the chat. SCOTUS blog is a really good resource for Supreme Court stuff. Here's SCOTUS blog. They have synopsises of all the cases. They have all the amicus briefs on there. And then when the case is happening, you can listen live there. You can also listen live on the Supreme Court's website. Another great website is OYA. I apologize if these aren't .coms, they might be .orgs, but if you just Google SCOTUS blog or Google OYA, you'll find tons of great Supreme Court material. The cases are usually starting at 10 a.m. So I know some of you might be in school at that time, so you won't be able listen to it. Although if you told the teacher that you were listening to a Supreme Court argument, they might, depending on what class you're in, obviously, they might not frown upon that, especially if you were in a history or social studies class. I'd argue that it'd probably be a better use of your time than maybe what would be happening that day. Just don't take it too far. If somebody questions it, then put the earbud away. Tomorrow, actually, at 10 a.m., there's an interesting case. There's a gun rights case out of New York, actually. So if people are interested in that, you can tune in at 10 a.m. But we'll definitely do another one of these for the Mississippi abortion case and see how it jives with this one. Any other questions or comments?
Just like a final comment, I feel like all of these like court cases and the judgments that the judges make, like less depend on their like values, but more like depends on like the situation and the circumstances that these like cases are like placed like upon. I thought that was really interesting, like the fact that this Texas abortion cases, these cases could be overturned in the future by like the same judges, kind of just demonstrates that these unique like situations could alter like the tide at any time.
Yeah, that's a really interesting point. So the justices have gone to great lengths to say that they just decide the cases that are before them based on the facts and based on previous precedent. They're not, like you said, they're not substituting their own values or political beliefs or partisanship into these cases. A lot of people think they are, but their argument is that like they're just neutral arbiters. They're like an umpire in baseball. They're calling balls and strikes. They're not trying to influence the game in any way. And people argue about that all the time. And so I'm glad that you brought that up. Where are you from, by the way? Just curious about how the court system might work where you're from, or are you from the US?
Well, I'm not from the US, I'm from South Korea, but I live in Italy, but it's probably like I've lived in the UK, so.
Gotcha. And have you felt like the court systems in the places you've lived are drastically different from in the US?
Yeah, I think it's a bit different. Yeah. I haven't like dug into a lot into like each court system, but I can definitely like tangibly feel the difference when I look at these like court cases. I think the basic like conflict between like federal and state court and like all of these kind of nature of these disputes kind of show how different these courts are, like, these like justice systems are.
Right. Yeah, it's fascinating to compare. I mean, there's a whole school of scholarship and research that is comparative politics, right? Comparing one country's political system to another. And I know that takes place with our country's legal systems and court systems too. Obviously, the US court system and legal system is based on the British system. So there's a lot of customs that are still there, but in many ways it's also very different. And that would be a fascinating topic to cover another time. But thank you for bringing that up. And so we're coming up on the hour. Thank you so much, everyone, for joining. I hope this was insightful. I hope you learned something new. And we'll do another one of these for the case in December. Have a great night, everybody.
Thank you.
Thank you.
Bye.
Bye.
Thanks.
Bye, thank you.
Thank you.